7:44, welcome back. We're taking a live look now from the White House. A fight between the Trump administration and two prominent law firms is heating up with more action expected to be taken today. Now, last month, President Trump signed executive orders terminating security clearances against firms who have represented Trump's challengers. Perkins Coie represented the 2016 Democratic presidential campaign for nominee Hillary Clinton, who Trump defeated. Covington and Burling represents Jack Smith, who was, you may remember, appointed as special counsel during the Biden administration in two criminal cases against Trump. Both firms are now barred from accessing government buildings where many of the other clients work. Which brings us to today. Both law firms expected to ask separate judges to block the executive orders, saying they're designed to punish and hurt the businesses. You got another firm, Jenner and Block. They're expected to take similar action next week. Whew, it's a lot to keep up with, right? So we've got our chief legal analyst, Khalif Rhodes, in this morning to kind of see where things go with the update today. Good morning, Khalif.
Good morning, Jason.
All right, so we talked about it a couple of weeks ago where these law firms are going, wait a second, we were doing what we thought, was our legal duty to represent or, to follow the lead in these cases. They feel like this has become sort of a retribution campaign from the president.
This is the second day we've said that folks are filing claim against the president for retaliatory actions. You're taking these executive orders. The other one was Harvard yesterday saying that you're taking and freezing our $2.2 billion. Why? Because we're not following and doing what you want us to do. It's retaliatory. We want the court to stop you from doing that. These law firms are saying the exact same thing. And as you mentioned, we weren't just following the lead or doing what we were trying to do. They were doing what their clients paid them to do. These aren't law firms that are doing this out the goodness of their hearts. They have clients that come to them. They ask them for a service. They do the conflicts check that's ensuring that, hey, I don't have anything in my background that prevents me from working with you going forward. Because I don't have anything in my background, meaning I may be representing the other party in the past or someone in my firm is representing the other party in the past. Okay, those conflict checks work out. We can move forward with our relationship and I'll represent you to the best of my ability. The law requires actually us as attorneys to zealously advocate on behalf of our clients. So actually, if you were telling those law firms to not do what their clients wanted them to do, you'd be asking them to violate the rules of ethics as an attorney. So put them in a really, really weird situation. But this is clearly retaliatory on his face. That's what the judge said when issuing the temporary injunction earlier. They're now asking for permanent injunctions, which is going through the same standard. It's just not as fast. So when I have a permanent injunction, we're going to have a full-fledged hearing. Yeah. Those temporary ones are hearings as well, but they're not going to be as lengthy and as long as this one will be, and we're not going to get a final judgment, some type of final order like we will get here. Those ones will be, look, I need you to act instantly, because if you don't act, Your Honor, in the temporary one, irreparable harm will come. If you don't act, there will be damages that I will not be able to fix with money. So I need you to act now. And now you can table these actions and allow us to talk about it at a later date. And that's what's happening on today. That later date is now.
The later date is now here. As I feel like these law firms and these educational institutions, universities, Harvard, like we mentioned, I feel like they have two choices, and it's almost the lesser of two evils. Either they comply and they agree to certain concessions, or they have the risk of pushing back. Either way, they're going to be doing something that could cause resistance, or it's a difficult spot no matter which one they choose.
It's a very bad and difficult spot to be in, but I mean, you have these risk management departments that are advising you on the cost. I wouldn't say they're bean counters, but they are folks that are saying, well, what is the cost for us to do litigation? What is the cost for us to comply? And in this outlier that's not money related, does it go against our core principles? If we're looking at the Harvard example, some of the things listed on the demands on those letters that were sent out on April 11th, they went against their core principles. So it wasn't even about cost. They just rejected it wholeheartedly because you're asking us to change who we are. Now, when we're talking about these other situations, in this case, these law firms, you're saying if you have now created executive orders that exclude us from these locations, now we can't even do our job. We can't even do our business. And so they didn't have a selective opportunity to accept or reject what the Trump administration was saying. This was retroactive. This was for what they've done in the past. Going forward, we won't allow you to work with us. So this wasn't like, okay, now you have an opportunity to not work with these people. They've already done the work. They can't go back and not work with these things, like with Jack Smith, for instance, with the Hillary Clinton investigations, with any of these things that happened in the past. It's already done. Yeah. So it's not a forward-looking action that he was having them do. It was because of something you've done in the past solely that now I don't want you guys to even have access to work with. And it's even further. I don't want other contracting companies to work with you, or they'll actually be barred as well. So it was two-pronged. Not only do these firms lack access now, that you're not even going to get the opportunity to work with other government contracting companies if they utilize you as a law firm. That's also the problem, because they're hurting their business on two ends.
Yeah, we'll wait to get the ruling on that, because that trickle-down effect could not only affect the Trump administration, but future administrations.
100%. Now, Jason, let me say this quickly. These firms aren't tiny firms. I got to be clear.
Yeah.
These are the biggest giants in the legal profession. All of these firms are bringing in hundreds of millions of dollars a year. And so, yes, losing contracts is bad. Losing clients is bad. But they're not like losing sleep over this. But you still want to be able to operate and not be constrained by an executive order for something that you felt like you were in the right for doing.
We'll be waiting on to see what the judge says. Khalif, thanks. We'll join you coming up in another half hour.